We want to welcome back John Rizvi to the program. He is the patent professor. He's an adjunct professor of patent law at Nova Southeastern Law School in Florida, and he is here to break it down for us, a case that just went in front of the Supreme Court of the United States. Good morning.
Yeah, good morning. Always a pleasure to be here.
Thank you so much. So let's talk. Let's talk about this particular case. On June 13th, the U.S. Supreme Court ruled in the Trump too small trademark case, and which that kind of may have revealed a little bit of a rift among the justices on First Amendment jurisprudence. But break that down for us.
Yeah, so a little bit of history for those that might not remember. I mean, in 2016, Donald Trump, during the election, was referring to candidate Marco Rubio as Little Marco, and he retaliated by making statements about the size of Trump's hands, and that kind of caught on and became, Trump too small kind of became a slogan, and it was registered, or it was filed. A trademark application was filed by an individual, and it was rejected because the Lanham Act has a prohibition against any trademarks identifying a living person without their consent. And the question became whether that was an unconstitutional restriction on free speech, and that's what the Supreme Court was looking at. They decided, actually, it was unanimous, that it was not unconstitutional, and that the Lanham Act applied, and that the trademark could not be granted.
And so that's over and done with because it is someone's name, and that follows what the law states, correct?
Yes, because it's someone's name, and previous restrictions on trademarks have been shot down by the Supreme Court as being unconstitutional. So that gave a lot of people hope that perhaps this restriction would be shot down as well. But there was a difference. The previous restrictions were on trademarks that were considered disparaging. For one case, Mattel v. Tam, it was a band that was going by the name The Slants, and they tried to register that, and it was found to be disparaging trademark against Asian Americans. And then another mark was the mark FUCT for a clothing line, and that was the trademark office rejected it as being immoral or scandalous. And the Supreme Court basically looked at those sections of the Lanham Act and said that if you are evaluating trademarks based on that are not viewpoint neutral, that those restrictions would be shot down. So there's no longer restrictions that are content-based by the trademark office. But this restriction on the use of someone's first name is not it's viewpoint neutral. It's not content-based. It doesn't matter what the name is. Anyone that's a living individual, you have to get their consent before you use their name as a trademark.
Now, that didn't apply when you had someone trying to trademark Let's Go Brandon, or no?
Yeah, I'm not familiar with the Let's Go Brandon and if that was filed as well as a trademark, but I don't recall if that was a name-based restriction, and then if they filed for that trademark or not.
Well, I guess the question would be, can you get a trademark just to ridicule a public figure?
So that's where the difficulty lies. Is that you can certainly ridicule a public figure, and that's protected expression under free speech. However, when you get a trademark, you are seeking exclusive rights, to use a name in commerce. And that, in that case, you can restrict free speech, because if it's a living individual, you have to get their name. Now, there's nothing wrong with ridiculing Donald Trump using the too small statements. It's just the trademark office cannot give exclusive rights to one individual for use of that term under trademark law.
Okay, and so, but apparently, and I've seen flags and banners and all of that sort of thing, even though you're not really familiar with the Let's Go Brandon thing, that apparently had to do with Biden and when that came out. And so you kind of see some things, but you're not referring to a specific person there. I don't guess.
Yes, and remember, just because you see merchandise or flags and such, it doesn't necessarily mean they're trademarked, which would mean one company has exclusive rights to sell a product or a service. So, what trademark law does is provide exclusive rights to one individual or one company to be the exclusive manufacturer of a product or a seller of a service, and that's not permitted. So, certainly the individual that filed for a trademark for Trump Too Small, there's no restriction on him selling T-shirts and putting that on his T-shirts or having other merchandise, flags or whatnot, with Trump Too Small on them. He just can't stop others from doing the same. So it's going to be a free market. Anybody can sell that merchandise, and no one would have exclusive rights to be the only one being able to sell those products. When he filed for a trademark, what this individual was seeking was exclusive rights to to sell the merchandise with Trump Too Small and prevent anybody else from doing the same. And that's what was rejected.
Now, should that case have made it all the way to the Supreme Court?
It's the Supreme Court granted certiorari or cert, and I think they took this opportunity to really clarify that there are restrictions on content that they are going to be okay with in terms of trademark filings, and that content-based restrictions, but those restrictions, as long as they're viewpoint neutral, and in the case of preventing a registration of someone's name without their consent, there's no restriction, there's no bias as to what the name is. Pretty much, it's viewpoint neutral, so that was permissible. The prior restrictions that the Lanham Act had was for marks that are disparaging or immoral or scandalous, and there's too much discretion there with the trademark office to decide which mark is scandalous or immoral and which one is not. And in that case, the restriction was held not to be permissible because it's not viewpoint neutral.
And John, thank you for that. Let's go over, sort of Patent 101. You have a website about this. You are the patent professor, and I take it that title has been patented, I would guess, because you have the little R above your name there. But I wanted to get you to go over what a patent is and when a person needs one.
Yeah, so absolutely. A patent, it protects a new idea, an invention, and there's different areas of intellectual property law. A trademark protects branding. So you can protect the name or the logo for something with a trademark. And as you mentioned, the name of my law firm is the Patent Professor. We applied for a trademark and obtained a registration for the Patent Professor. And when you do that, that's how you indicate that it's a registered trademark with it, putting an R with a circle around it. And what that does is it prevents anybody else from offering legal services in intellectual property using the Patent Professor as their brand.
And tell us what the 4 classes of patents are.
So you can get patents for a process. That's one of the categories. And a lot of times you'll see software apps being protected. That's how you get software protected, and apps, and through a process. A machine, any sort of machine can be protected. A manufactured item, that's your typical, stapler, telephone, iPhone, gadget, whatever it is, or a composition of matter. So you could get a chemical formula protected. You could have a protein powder protected as well. So those are the 4 statutory categories of an invention. The one that's really getting a lot of attention currently is, of course, processes or methods, and that's what most software patents and patents on applications on the iPhone, for example, or any smartphone. That's how they're protected as processes.
Thank you for that. We have been speaking this morning to John Rizvi, and he is the patent professor. He is also the author of a couple of books. One is titled Think and Grow Rich for Inventors, and Escaping the Gray is the other one. And John, thank you so much for being with us this morning to break it all down. And where might our listeners pick up your books?
Yeah, so you can find them on, of course, on Amazon, Barnes and Noble. They're in physical bookstores as well. But you can have audio copies on our website, thepatentprofessor.com, and you'll certainly find links to those anywhere on social media. And our handle is The Patent Professor, whether on Facebook, Instagram, or TikTok, anywhere. We're type in The Patent Professor, and we're the only ones that come up.
All right, John Rizvi, thank you so much for being with us.
Always a pleasure. Thank you.